Так, ще є 2 хвилини, я можу продемонструвати екран. Чи я не знаю, зачекати 2 хвилини, поки приєднаються
Okay,
учасники?
while we're waiting for another 2 minutes until everybody joins, let me just show for those who are here.
Треба пізніше ще раз продемонструвати.
And if necessary, I'm going to demonstrate this again, where all the files are.
За тим посиланням, яке ми
Look, if you
надіслали,
follow
ви
this link,
надіслали, ви переходите
it's
на
called
такий
padlet.com.
ресурс, така платформа. І
So
тут
you can
ви
go to
можете
this
розбирати
platform,
на 2 мовами
and you can see
презентацію,
everything in both
відео,
languages.
програму,
So you can see the
інформація про
agenda, the
організацію,
speakers in Ukrainian,
інформація про
all the
партнерів,
background
про
information
партнерів
about the
форуму,
speakers and
про
partners
посилання
to
на
this forum with all the links that you can
програма.
follow
І
and
далі
read
ви
more.
рухаєте
And as you scroll
вправо,
it
і ось тут по дням.
to the
Кожен день,
right, you
сьогодні
can
25,
see the agenda for every single day. Today is the 25th. So you can scroll it down, you can see all the speakers, the agenda, everything, all the files, presentations. And on top of that, we have background information about speakers, both in English and Ukrainian, with pictures and short bios, so you can actually see the presentations in Ukrainian and also in English. Moreover, there is a folder with additional materials. For example, yesterday we were discussing the Code of Ethics from the IMI. And you can also find those translated presentations with links to the handbook, which we presented yesterday. And it's going to be the second edition this August already. So you just scroll to the right and to the left, and there you're going to find all this information. It's not the first year that we've been using Padlet. It's stored there safely, and you can go there anytime and retrieve all the information.
Oh, I think we need to start, yes, in time. And my warm greetings, dear colleagues. Let me welcome all of you on International Forum Mediation and Law and our panel discussion, Evolution of Mediation, Current Trends and New Perspectives. It's a delight to see all of you, our speakers, our friends and partners, all of participants from all over the world. And we really appreciate that despite time zone differences, summer family vacations, mediations, each of you has done everything possible to be with us today and share your experience and expertise. Mediation is a constantly evolving field with new developments, discussions, and approaches emerging all the time. And I think it's important for mediators who want to remain relevant and effective in their work to keep abreast of the latest trends and topics. Each country, each mediator has their own experience, which is unique and valuable, and everyone follows their own path. But I'm convinced that our stance is in unity. And today, our speakers will share their experience, best practices, ideas, success stories, and lessons learned. So with each of us can take away something valuable and important for ourselves. And it's my great pleasure to introduce you, our distinguished speakers today. Dr. Mary Lou Bryant-Frank, psychologist, court-approved mediator, mediation trainer, and consultant, co-founder of Transforming Mediation. Ahmad Hussain, Senior Research Fellow with Singapore International Dispute Resolution Academy and Independent International Arbitrator and Accredited Mediator, Cedar IMI CME, Victoria Harris, Advocate, Mediator, and Deputy Chief Executive at the Civil Mediation Council and Trustee of Mediation, Hertfordshire. Willem Ruiterman, Mediator, President of the Dutch Mediation Association. And Luciana Dumel Diaz, Academic Director, Conflict Resolution Connection. Welcome, dear speakers. Thank you so much for joining us today. a small organization point, I propose to organize our work in the following way. After each presentation, we will have a maximum 1 or 2 questions, and all other questions will be asked at the end of the session. And also, please, you can ask questions by voice, and they will translate it if it's necessary. So let's move on. As we have talked, yes, mediation is not static. It's constantly evolving, considering new realities of life, new technologies, adapting to new challenges that rise in conflict resolution sphere. And every time we as a mediator, as a peacemakers, face very deep processes that are based, among other things, on the psychological components of mediation. And understanding and analyzing these components is an important element in the process of continuous development of our skills and help to change this world a little bit better. And with great pleasure, I would like to invite Dr. Mary Lou Bryant-Frank, author of the book, The Mind of a Peacemaker, The Psychology of Mediation, to share with us what are the current trends and new perspectives on mediation from a psychological perspective. Please, Mary.
But you're gonna have to unmute
Thank you
yourself.
so much.
Otherwise,
for
I
the
cannot
lovely introduction.
read it.
Thank you for putting this incredible group together. I know how much how much work these things take, and just it was a pleasure to see both you, Svetlana and Luisa, in Vienna just a few weeks ago. And I'm very honored and humbled to join this distinguished panel. So thank you all so very much for letting me be here. I am going to go ahead and share my PowerPoint. And if all of you can see it, if there's a problem, please let me know in the chat, and I'll try to see if I can't, the chat just, well, I don't see the chat right now, but that's okay.
It's not full screen yet.
There we go. Now I see it.
It's
You're
not full screen. Can you make it full screen?
All right, let's go ahead and talk a
cannot hear
little
me.
bit about what I said. I have a great deal of respect for Ukraine, and have done a lot of training and teaching of Ukrainian mediators and attorneys and work. I've been in Ukraine several times, so getting a chance to be asked to speak to this had a very special meaning to me. My background.
Хвилиночку, я попрошу звернути увагу.
Just 1 second, Mary Lou.
Мері, у вас не на весь екран
It's
зараз
not full screen
іде
yet,
презентація, і ми бачимо
but we
частину
wanted to
робочого
see it. We
столу.
can only see part of your
Okay.
desktop.
My background is that of psychology, and that's a little different than law, because while people were studying laws and how the different kinds of laws interact and how to best even be able to represent people in the court system, I was studying two things. I was studying about research, and I was also studying about how to help people, how to help people change, and the different ways you can help people and groups get along together and work together. So my background's a little bit different. And I think you've already heard my approach. Basically, I'm looking at not just trends of where we're going, but maybe we need to keep also in mind what we need. The first trend I'm going to talk about has its roots in lots of research. So the trend started in 2016. That was when it was first documented. It's only continued during that period of time. And what I'm looking at, as you all took care of the screen, I'm not able to see the chat. So if there's something I need to know, you need to let me know, because I can't see that anymore. It started with the Maryland judiciary, who started saying what's going on in mediation, and then the American Bar Association. Whistler and Weiner took some of the data the American Bar Association did and dug deeper into it. Galton, Love, and Weiss did an international study of mediators, and Whistler and Henshaw continued to pull things together of what we've been learning about caucuses. And caucuses, just as a brief reminder, you use a caucus in mediation when you want to break up from talking to both of the parties and you want to speak with them individually. So you bring the parties together. If there's a stalemate, a caucus allows you to break them apart, meet with one side, meet with the other side, and then hopefully bring the parties back together and help them work out the issues. But the trend changed. And the trend, which was everybody stayed together except for a couple little breaks. Now, all of a sudden, most people were in caucuses over a third, or at least a third of the time. And together, they were only together maybe, 1/3, and then they were separated 2/3 of the time. So most of the time, people weren't even ever getting together. And if you look at it, for some people, people are never in joint session. 70% of the time, what mediators are doing and what they're calling mediation is really nothing other than negotiation in the form of shuttle diplomacy. In other words, they never bring the parties together and they go back and forth. Now, I know why that's happening. It isn't that people are really trying to do something different, but they're doing it because it's quicker. They think maybe I won't have to deal with the people who are in conflict if I separate them like that. But we know that there's really some benefits of keeping people together. It allows them to come to a settlement that they're satisfied with. It allows them to give their own suggestions and be able to work out things with the other party, to deal with the relationship issues and any of the emotions that are there, which never get resolved if they never get to talk with the other party. Working to build trust, empathy, and process what's going on can't happen when you have people in different rooms, because we know that when you're in different rooms, you don't say the same thing when you are separated from when you're together. You have a tendency to you look at your words, you realize you've got to make a genuine connection at that point. And that information came to us from Lewis and Embright back as early as 2015. People want to have a safe place to talk freely. They're satisfied with mediation when that happens. So let's see what else came out of the ABA study. When the American Bar Association read about the study that had happened in Maryland, they said, that can't be happening. Mediation is when you bring people together. What do you mean people aren't bringing the parties together anymore? Well, the ABA found exactly the same thing that was being found in the study that came out of Maryland. A lot of the mediators weren't doing they needed to reject the caucus a little more often, but that's not what they were doing. They were caucusing all the time. Mediators needed to reflect emotions and interests if they wanted to be successful. They needed to get solutions from the parties, and they needed to be increasing people's willingness to go to mediation in the future, but none of these things were happening. People were caucusing all the time, and they were shocked by this. Galton, Love, and Weiss said, what's happening internationally? What is the trend? What are the practices? Well, the practices are the same things that they found in the study that the American Bar Association did. People were going into caucus from the very start. And people were leaving not satisfied with mediation. As a matter of fact, a good number of them were going back to the court system to get their issues resolved because they couldn't get it resolved in this caucus-only model of mediation. And people were starting to lose faith in mediation. And that happened 3 years ago. So people started asking, what does the choice of caucus versus joint session really reflect? Well, the people who were doing mediation said, well, we're just trying to get it finished as quickly as possible. We're trying to get a deal done. They weren't trying to develop understanding, increase satisfaction, or really talk about people's issues instead of positions. They weren't talking about feelings. They were just dealing with the facts and trying to resolve it as quickly as possible. So a model that was meant to help bring people together, the trend has been, and I'm really glad it hasn't happened in Eastern Europe yet, but the trend internationally beyond Eastern Europe has been, let's separate the parties and see if we can't get it done without even having to bring them together. But we know this. We can have a better resolution through direct communication. When people are in the same room, there's a benefit of keeping them together and helping them learn to work together. And moreover, people are more satisfied with the mediation when they have a chance to be together and work together. But it takes some skill. And that's incumbent on you and me and everyone else who does mediation. Let's talk about the second trend. And I know my distinguished colleagues will talk about this. The trend toward using technology in mediation is on the rise. And it's because, again, it is expedient. It gets mediation out there. It saves time. It allows us to take a whole lot of information and analyze it very quickly. It's accessible, it's efficient. And I'm citing research that has come out just this year on the benefits of using artificial intelligence in mediation. It saves money, it's more direct, and it's just seen as really transforming the field of mediation. And I think those things are true. The issues with AI, and I think over time we will solve these, but we haven't solved them yet. What's important to remember is that there's bias and discrimination in AI algorithms. Chatbots are often unstable, and they're still in their infancy, and we're still learning how they worked. Know that this model did not work in psychology when they tried using it a few years ago. They're still trying to refine it. So we can't just pick it up and say, this is what we're going to use, even though people are using it, and think that it's going to be 100% effective. You can't generate creative solutions with this. And that's why I think AI needs to be something that we use in conjunction with mediation. But if it takes it over entirely, look at all the things we're missing. And we need more technological expertise when AI isn't working. There are potential ethical and legal issues, as well as a very difficult time dealing with empathy, emotions, anger, cultural differences. AI lacks emotional intelligence. And that's what all these squares on your screen have right now. And that's the ability to connect with other people. That human connection is important. Cultural factors aren't recognized or addressed. It's too complex an algorithm to be able to just put into a computer. That's why using it in conjunction is much better than saying that's what we need to be doing. Remember, as mediators, we have some unique skills if we just use them, but it is going to push us to use those skills. It means we've got to develop, if we don't already have them, the skills at dealing with complex emotions. Whenever I do advanced mediation training, people always ask me, how do I deal with anger? I said, that's going to be your strength, is knowing, first of all, if they express anger, they trust you to deal with it. Learn how to address that. First, learn how to deal with your own anger. Then you won't be afraid of theirs. You'll help them use that to get them through the conflict. If what we do isn't replicated very easily, then we have something that's very unique to add. If all we're going to do is move into that shuttle diplomacy, that can be replicated. But what we know best about mediation can't be. The third trend, which is again a plus and a minus, just like the others have been, is that mediation is expanding everywhere. The fact you all are talking about it is a reflection of the fact people all over the world are talking about it. It's complex, but it has the potential to give people so much more satisfaction. We just need to realize it's getting everybody on board and getting enough trained mediators. And if we get to the point where we have too many, well, there's nothing wrong with having too many people who know how to negotiate peace. And we need to be supportive of mediations, and we just need to be flexible. But what's important for all of us is we need to be mindful. Our desire to be expedient may devalue the real effects and benefits of mediation. But we can be thoughtful about these trends. And I'm looking forward to hearing what all of my colleagues say and pay attention to the impact, the effectiveness, and what those outcomes are. We need to stay focused on who we are as mediators and remember each of us can be the peacemakers. We need to be aware, thoughtful, and remember who we are. We're there to help people work together better. And I'm going to stop sharing. So if there are any questions that you might have.
Thank you, Mary Lou. Really fascinating presentation, and you really brought a new dimension to the understanding of mediation. And please, I invite to share our audience your thoughts or questions for Mary Lou, but please one or two, and another questions come later, okay? Please, I have the raised hand.
Yes, please. We have two people raise their hands. Who would
Mr.
like to?
Desiree,
Desiree, please.
ask your question, Mr. Desiree.
Yes, thank you very much. Good afternoon. My question is how a mediator in a refugee community can have a good behavior just to make a very important mediation between refugees, like me who make mediation in a refugee community in Imam refugee camp in Rwanda. What would be the better behavior of a mediator in such a situation of a mediator in within a refugee community who are made up of different nationalities? Thank you.
Let me make certain I understand your question. Thank you so much, Desiree, for your question. Understanding, those cultural differences is critical. And I think that's what you're asking about. How does a mediator, am I understanding you correctly, work in an area where you're dealing with very different cultures or different experiences? Is that correct?
Yes, you mean
Is that what that is your question?
Yes, my question is I want to know for you, what would be the better behavior of a mediator in refugee communities who are from different nationalities? For
Okay.
me, for example, yes.
When you have different nationalities, what's very important is, especially, and this is true for me, I'm a white person from the United States. So I'm always aware that that is a variable if I'm working with people who are different than I am. So I always, have to be aware of what the cultural differences are. If there are differences that by which, and I will ask the people I'm working with, do you feel comfortable? I have studied each of your cultures. I think I understand some. I will never fully understand. And before the mediation, if they feel they need somebody at the mediation table, a co-mediator who represents one of their interests, then I would bring in a co-mediator. If I were dealing with a group of people, let's say who are from let me pick a country, who are from Vietnam. I obviously am not from Vietnam. I can try to understand their culture, but I may not understand all of it. I would say, would you like me to have a co-mediator who is from Vietnam, where we can work together and you can make certain somebody hears and understands exactly what your position is? If you're doing a very large mediation and you're dealing with two very large groups and they are both different than who you are, then you may want to have people representing each of them. You're working together as in mediation. Many times people will trust you or trust me because they know we have worked to help understand them. But if there's ever any if they have any doubt that I may not, that they need somebody other than me to be able to navigate the conflict with them, then I bring somebody else in who may understand their unique cultural perspective better.
Yes.
Does that help?
Thank you. Yes.
Okay, I hope that was helpful.
Thank you so much. And we continue our session. And I want to move on to a very important and at the same time interesting issue that never loses its relevance: the mandatory mediation, the forms and boundaries of this mandatory nature. And this is an issue that always causes big discussion. Some countries have already gone through this process and developed their own form of mandatory mediation. For instance, many countries have gone ahead and introduced a first mandatory information and assessment meeting with the mediator for certain categories of disputes. And with this concept also close for me, and I hope that Ukraine will gradually follow this path as well. And in this regard, I would like to welcome our next speaker, Ahmad Hussein, who will inform us today about the situation with the introduction of mandatory mediation in a region that is developing rapidly and about which we have no sufficient information: the mandatory mediation in Saudi Arabia and United Arab Emirates. Ahmad, please, floor is yours.
Thank you. It's really a pleasure to be with you today. I am aware of the 15 minutes allocated for the presentation, so I'll stick with these 15 minutes. But if you allow me, before I start talking about my topic, first of all, I would like to thank all the participants from different parts of the world. So I will tell them good morning, good evening, good afternoon, and it depends from where you are participating. And it is very easy to know that this 8th edition of this forum is having a legacy and credibility, because to have triple digits, whether more than 200 and 300 attending the sessions, even in different time zones, this is a testament that there is a huge efforts organized by the Ukrainian Academy of Mediation, the EU, of course, Ms. Louisa, and the fabulous team members of the Academy for their hard work. I would like to thank them not only for inviting me to be here with our distinguished guests and speakers, but also to exert and to dedicate such efforts for this highly interactive mediation knowledge platform. Thank you for that. Regarding the mandatory mediation, if you allow me to do the screen share, and I hope I am allowed for that. That's perfect. It's okay now? If the screen is okay. Great. My topic today is actually about the evolving landscape of ADR in the Middle East, with a focus of mandatory mediation on Saudi Arabia and United Arab Emirates. Before I take you into this journey, please allow me just to establish a mutual understanding that the Middle East and North Africa region is almost 22 countries, and in some literature 21 countries. And out of these 22 countries, there are 12 countries that having mediation legislation. These 12 countries, they are Algeria, Jordan, Qatar, Oman, Bahrain, Sudan, Saudi Arabia, United Arab Emirates, and other countries. And out of these 12 countries, there are 2 countries that having mandatory mediation, which they are Saudi Arabia and United Arab Emirates. That's why my focus today on these 2 jurisdictions that having mandatory mediations. And my topic today, I'm going to go through quickly on the definition of mandatory mediation. I'm sure most of us know the definition, but also we need to know the benefits and the criticism, and then the forms of these mandatory mediation, and then the steps of sanctions or mandatoriness, as our colleague Docris explained yesterday, and then how is the mandatory mediation operates in Saudi Arabia, and then how it operates in UAE, and then with the findings of these exploring at these 2 jurisdictions. Mandatory mediation, it's a very debatable, and in every single seminar now, especially after the UK already adopted the mandatory mediation, it is there in different jurisdictions. It is in Germany, in Italy, in some parts of Canada, it's in India, and the mandatory mediation is, in simple words, it is an attempt to avoid the litigation by resorting to the court in order the court to manage, facilitate, and encourage the parties to settle their dispute. That's in a very simple words. In terms of benefits, it is an access to justice. It is depends also on party autonomy, and it is a sort of efficiency. And those countries adopted mandatory mediation, they see that this is an indirect way to teach and to disseminate mediation and to raise the culture of mediation among the end users, because being mandatory, by mandatory, you have to come to the court. It means that you will know what's mandatory mediation and what's mediation. So that is a sort of indirect raising awareness of mediation. Regarding the criticism, I'm sure most of you are aware of this critique about the mandatory mediation. It is versing the voluntariness of the mediation, and most of us who come across the Law Commission in the UK while they are processing the consultation, this is the point raised in several jurisdictions, that how can we maintain the balance between party autonomy, voluntariness, and to be by force, you have to resort to the court. So this is the first critique. the second critique, this is an additional barrier to the justice, because in some jurisdictions, the parties take this mandatory mediation as a way to just go there to say, yes, we have tried mediation, but it doesn't work, so let us go for litigation or for arbitration. And at the same time, it affects the quality because it is rather a voluntary process. It will turn into something procedural. And that is the most important three critiques for the mandatory mediation. In terms of the forms, if we have helicopter view, holistic view in the jurisdictions that having mandatory mediations in Germany, in Italy, in UK, in Saudi Arabia, in United Arab Emirates, and in other jurisdictions, they are categorized into four categories: the discretionary mediation, the categorical, the quasi-compulsory, and the contractual. To make this in a very simple way, this is a chart by our colleague Docris about the level of mandatoriness. It starts from being discretionary until it is being no exemptions, that you have to resort to the court. And from 1 into 5, there are different variations of the countries that having here their positioning in mandatory mediations. Of course, due to time limitations, will not be able to explain, but this is the chart that best depicts the sanctions and voluntariness and mandatoriness in mediation. In Saudi Arabia, which is very important, before I talk in Saudi Arabia, before I talk with Saudi Arabia, I would like to share with my colleagues, my friends, and the participants that most of the Gulf countries, I mean Saudi Arabia, United Arab Emirates, Qatar, Oman, and other countries in the Gulf states, they do have economic vision. Saudi Arabia 2023, economic vision, United Arab Emirates also economic vision, and other countries. And the policymakers over the last 5 years realized that investments, attracting investments, availing legal framework cannot be achieved without having an efficient ADR system in place. So they start in the last 5 to 7 years adopting legislation and mediation in order not only to solve resolutions, but to be part of the global business players and to be in line with the doing business and with attracting foreign direct investments. This is one of the most important rationale or points behind adopting the mediation. Saudi Arabia, this commercial court, it has been introduced in 2020, so it is almost 4 years now. It is for certain type of disputes. It is actually categorical, and the proceedings lasts only for 30 days. And after that, if it is not resolved, it has to be to the court, the competent court. And mediation in Saudi Arabia is not conducted by the court, but conducted by a center affiliated to the court. And this center called Reconciliation Center, rather Mediation Center, because as you know, and as our friends in the morning sessions, they have been talking about the dilemma of the terminologies of mediation, conciliation, reconciliation, to the same situation in the Arab countries, that the legislators have adopted different terminology. Out of the 12 countries in the Arab countries, 9 countries having the terminology mediation, Saudi Arabia having reconciliation and mediation, Sudan only conciliation, Oman reconciliation and conciliation. So with these different terminologies, and of course that is part of so many things, but mostly to the cultural considerations. Also in Saudi Arabia, also in the UAE, they have adopted this mandatory mediation in 2023. And allow me here to just remind our audience, our participants, that the reasons for Saudi Arabia and United Arab Emirates to adopt mandatory mediation, because they realize that most of the parties, they think that the judiciary system is an efficient system, reliable system, free of charge system, especially in mediation. So let us optimize and maximize this mindset of the end users, of the parties, and introducing the mandatory mediation. What makes the situation in United Arab Emirates different, that the court also referred disputes to mediation. It is different from the situation in Saudi Arabia, where it is categorical, because it is here discretionary, and it is mainly about civil and commercial disputes, and mediation here shouldn't exceed 3 months, while in Saudi Arabia it is 30 days, 30. And of course, there are some considerations regarding that. In Saudi Arabia and United Arab Emirates, there are preconditions for cases to be mediated in terms of value, in terms of types of the disputes. In terms of value, it shouldn't, in Saudi Arabia, it shouldn't exceed 1 million dirham, Saudi riyals, which is almost more or less 250,000 US dollar. In UAE, there is no value for that, but it is also discretionary for the judge to use this one. Actually, empirically and statistically, there are several findings, and very important findings, from both Saudi Arabia and United Arab Emirates regarding the mandatory mediations. First of all, the Saudi Arabia is categorical, and in United Arab Emirates it is discretionary. That is in terms of the approach, and in terms of the statistics, which is crucial. I'm sure during today's sessions and yesterday there is always a reference that how to measure mediation, how to make sure that the process is efficient, effective, and having fruitful results. If there is no results, there is no figures, there is no way to measure the efficiency. Unfortunately, that is a challenge in both systems, that there are not officially declared statistics about the rate of settlement, about the number of cases, and about any quantifiable or quantitative or qualitative research that's showing us the challenges, the impact, and the results. But I think now that hopefully in the next few years, there will be a change from the court system to disclose and to publish all these statistics, because no way for the ecosystem of mediation to be efficient and to be at its best without having these statistics. That is, I think, the most important challenge in both jurisdictions. I'm aware of time, but if I would like to conclude this very brief presentation, I may share with you 3 points quickly. One, still in Saudi Arabia, United Arab Emirates, the remaining jurisdictions that having mediation legislation, there are 12 countries. Still, there are pillars needs to be built in regarding the ecosystem in terms of the code of conduct, in terms of raising the awareness, in terms of having harmonized approach, in terms of so many things it has to be done in order to enrich and strengthen the landscape of mediation. Second note of mine as a practitioner and also a trainer of every day of this in this region, that it seems to me that because of mediation has come to stay out of attracting investments and out of being part of the regional and the global players, it needs the buy-in to be at the top level of the policymakers and legislators, that mediation has come to stay, but you need to pay the ecosystem price to be there. The last note is that there are increasing awareness now, and there are the will. But if you have the will, you will have the way. But having the will and the way is not enough. You should have the capacity building roadmap to go ahead. That's my word for today, and thank you for your time.
Thank you so much, Ahmad, for your presentation. I highly appreciate your expertise. and where you have highlighted the mandatory mediation. And please, let's hear one question from our participants. I see the raised hand. Please, Irina Antonenko, you may go.
Yes, hello. I wanted to ask you about mandatory mediation because it's mandatory if it's conducted with a voluntary participant in mediation. And how do you think if the participant didn't show up on the mandatory mediation in court and the court will put negative sanction on it, how it will be reflected on the mediation at all?
Thanks. That's very important question. I hope, am I audible? Okay, that's really very important question, and thank you for that. Actually, one of the weaknesses now of this mandatory mediations, both in Saudi Arabia and the United Arab Emirates, there is no sanctions. If the parties didn't show, if the respondent didn't comply and show, there is no sanctions for that. But currently, the legislative committees are studying the best way forward, because in Saudi Arabia, there will be a legislation on mediation that will be enacted shortly. So part of this, part of the discussions now with the stakeholders, how to introduce sanctions scheme in order to make sure that the outcome of this mechanism of mandatory mediation will be fulfilled. And also to the same situation in United Arab Emirates, there is no sanctions, same as other jurisdictions. I hope I answered your question.
Thank you. Now
Yes, sorry. Yes, you did answer my question, but I was asked about like general procedure, because in UK there is a sanction when you not show up on the mandatory mediation.
And the procedure, I'm sorry if I didn't correct the process clearly. For voluntary mediation, if they have resorted to the mandatory mediation under the current act of commercial court, because it's mainly and only in commercial disputes, not in civil disputes, not in family disputes. It is only in commercial disputes. So until now, there are two ways actually, whether the parties, if they have certain type of disputes, they have to go to reconciliation center by virtue of law, because it is mandatory against certain criteria, or during the proceedings, the judge can refer this dispute to the reconciliation center under the provisions of the mandatory mediation. So there are two ways, whether at the beginning or during the proceedings. And I'll be more than happy to send to my LinkedIn or to whatever the further questions, and I will give you further details.
Thank you so much. And now I propose to change the focus of our attention a little bit to the question of resolving conflicts that rise in communities, and mediation is a way to resolve them. In fact, this issue of conflicts in communities is relevant for all countries, and conflict that arises within communities over domestic matter, culture, language, religious, land, and other matters, yes, can eventually turn into political conflicts, and like snowball is gaining volume. Therefore, it's very important to introduce various projects, initiatives, and support of government, of course, for mediation as a tool for resolving such conflicts. I'm excited to give the floor to Victoria Harris to share her experience and experience of United Kingdom in development community mediation. Please, Victoria.
Lana, thank you so much, and good afternoon, everyone. At least good afternoon from where I am in Hertfordshire, just north of London. I'm honoured to be able to contribute to this panel, and my thanks to the Ukrainian Academy of Mediation for your kind invitation. It's great to see so many friends and colleagues at this event today and have the opportunity to make lots of new connections. So thank you for bringing us all together and for enabling this global learning experience.
Sorry, can it be a little bit louder because I can barely hear you? Thank you. Sorry about that.
Hopefully that's a little bit better. I'm also you have my huge respect for the amount of preparation that's gone into this conference. So once again, my thanks. And conscious of time, I will move on to the topic of evolution of mediation. And I think when we think about the evolution of mediation, we tend to think about the growth and the expansion of mediation. And certainly in England and Wales, there has been a period of growth for mediation within our court system in the past 12 months. Earlier this year, money claims with a value of less than £10,000 began to be automatically referred to mediation processes within our civil justice system. And in addition, in an historic case, a ruling was made that parties could be directed to engage in non-court-based dispute resolution processes such as mediation. There's also been discussion about automatic referral to mediation being expanded to higher valued claims in the future. But at times of change and progress, it's necessary to think more broadly about the impact of the growth of mediation and how it can best be sustained so as to support the continued evolution of this form of dispute resolution. And public awareness of mediation, what it is and how it works, has never been more important. Work to make mediation mainstream must accompany any system change to both support engagement with mediation and to promote better outcomes. So as is the case with many countries across the world, community mediation, which takes place outside of the justice system, plays a crucial role in raising public awareness of mediation, as does the work carried out by many community mediators to educate the next generation about mediation in our schools. And that's why today I'm going to speak about the evolution of community mediation in the UK, not least as it serves as a timely reminder to us all that evolution is not guaranteed. Mediation needs the right conditions to thrive and requires continual nurture. So my apologies for not engaging you with an attractive PowerPoint presentation to capture your imagination in the way of my esteemed fellow panelists. But it may help to know I'm going to be looking briefly in my short presentation at the past, the present and the future for community mediation in the UK. So let's begin in the past. It's fair to say that the development of community mediation in the UK has not been linear or incremental. It's generally accepted that the first community mediation schemes in the UK appeared in the 1980s. Many were concerned with victim-offender reparation. And in 1985, only 2 schemes, both based in London, were concerned with wider community conflict. And what followed was really fascinating, a period of huge growth such that in 2005, there were over 250 organisations supporting community cohesion across the UK. So why did this growth occur? Well, firstly, many organisations were funded by their local councils who saw the benefits of community mediation, particularly in relation to disputes involving tenants in social housing. Secondly, an umbrella organisation, Mediation UK, which was partly funded by the Home Office, had been set up to establish more community mediation organisations. They hosted an annual conference and generally supported the sustainability of the sector. But as I mentioned, the development of community mediation in the UK has not been linear and drastic change was on the way. Today, the number of community mediation organisations in the UK sits somewhere between 40 to 50, down from its high point of 250 in 2005. So why did this huge decline take place? There are three key reasons. Firstly, austerity. The financial crisis of 2008 hit local authorities who withdrew funding from community mediation organisations. Secondly, the responsibility for mediation moved from the Home Office to the Ministry of Justice, which arguably naturally shifted the focus of mediation towards its use within the legal system. And thirdly, Mediation UK itself, the organisation I referred to earlier, had some of its funding withdrawn and it closed in around 2005. These three factors left the community mediation sector with little support. Those that survived after 2010 were schemes that relied heavily on volunteer activity. And for the past 15 years or so, the huge potential for community mediation in the UK has remained subdued. Fortunately, that's changing, as we'll see. And I'm going to turn now to tell you about the present day for community mediation. The good news is that organisations that remained after 2010 have become pretty resilient. Points I'm about to outline demonstrate the effort that it's taken to sustain the sector and put it back into a growth trajectory. So firstly, community mediation organisations now ensure a variety of funding streams to avoid the fragility of having, as we would say, all of their eggs in one basket. They've widened their offer, moving from largely supporting the resolution of housing disputes to now supporting community safety and also the health sector, which I think is an acknowledgement of the impact of conflict upon health. These organisations have also professionalised. They adopt high standards, they have insurance, their volunteer mediators are screened through a system known as DBS checking. They're trained to safeguard vulnerable individuals, and continuing professional development and training is an important feature of their work, ensuring the quality of the mediation services they deliver. Another development that's helped to elevate the sector is the work that's been carried out to raise its profile. Mediation Hertfordshire, a community mediation service just north of London, have published 2 reports, Transforming Community Conflict and The Cost of Community Conflict, both of which have been supplied as part of conference documentation for today. These reports have been widely circulated to local authorities, police and crime commissioners, health chief executives, and our members of parliament at Westminster to spell out the valuable contribution that these services make. And last year, the Civil Mediation Council created a platform for the community mediation sector, and now a working group comprising of some 22 community mediation organisations meet every quarter to share learning and work together on projects to help raise the voice of the sector. One particularly exciting aspect of this group is that we're seeing people come forward who want to set up new services. And the next planned project for this community mediation working group is to create a digital poster identifying where existing services are based so that individuals can find their nearest service, and for this poster to be circulated to doctors' surgeries and other public spaces, raising public awareness of mediation and promoting accessibility to it. So bringing us right up to date with current developments, on the 1st of June this year, CMC published an accredited standard for community mediation organisations so that they can demonstrate the high quality of the service that they offer. And it's anticipated that this will support funding bids and will be a significant step to further elevate the profile of the sector. So in conclusion, it's useful to look ahead to the future. As we're now expecting our citizens to engage in mediation within our justice system, It's crucial that public awareness of mediation is increased, and community mediation has a huge role to support that. Here are 4 things that, in my personal view, may help to nurture the continued evolution of mediation, both inside and outside of the court process in England and Wales. Let me explain. Firstly, we need to grow peer mediation. Some of you may be familiar with this work, which teaches the next generation about conflict prevention and management. Much of this work is delivered by community mediators who teach students about conflict prevention and management and help them to learn mediation skills to support conflict resolution in their educational establishments. It's timely to look at a consistent rollout of this learning within education so that we can better explain to the next generation what mediation is and how it works. Secondly, we need to give more thoughts to how mediation can be linked with the health sector. One way to do this would be to boost the practice of social prescribing of conflict coaching and mediation. This would be a major development to support the evolution of mediation if doctors' surgeries were able to socially prescribe mediation or conflict coaching to patients who are experiencing the adverse impact of conflict upon their health. Many of us will understand the trauma that can arise from conflict and how medical solutions can often only treat the symptoms and not the root cause of the problem. Thirdly, we need to look at delivering more programs of conflict prevention training within communities. Many politicians have spoken of the importance of community cohesion and tackling polarisation in communities. As you'll recognise, this is a theme that goes beyond the remit of any one political party and may also resonate across borders. Community mediation organisations here are engaging in this type of conflict prevention work and include group training sessions that seek to preempt disputes and de-escalate conflict, whilst at the same time introducing mediation skills and techniques to the wider public. A fourth and final point, which would support the continued evolution of mediation, is to explore the development of a locally delivered and nationally funded community mediation service. Such a service would ensure that individuals have access to mediation for non-court related disputes. It would support those whose health had been impacted by conflict, and it would support communities experiencing division. It would also help to teach the next generation the lifelong skills of conflict resolution to help prevent disputes, as well as encourage engagement with mediation in any future court-related dispute. In any country, the cost of conflict is high, both to individuals who suffer the impact of conflict and the public services that support them, such as health, housing, education, and community safety. In the same way that the CMC have supported developments to embed mediation within the justice system in England and Wales, we look forward to supporting the continued and complementary evolution of mediation in a community context. I'm very grateful to you all for listening to that presentation, and I really welcome the opportunity to learn about the systems of community mediation where you are based. So please do connect with me on LinkedIn if you wish to continue that conversation. And Svetlana, I'm very happy to answer any questions.
Thank you so much, Victoria. We're impressed with your presentation, and you have covered many aspects of community mediation that are worth considering. And I see 2 raised hands. Okay, please ask your questions. Who is the first?
Hello, it's me again, Irina. As you may know, a lot of Ukrainians came to UK because of war, and quite of them have mediation qualifications. And then you need to be registered with CMC as mediator to be able to practice in UK. Do you know if could be possible to arrange improvement of qualifications for Ukrainian from CMC, or how it could work, and could Ukrainian be involved in mediation society in UK? Thank you.
Irina, thank you very much for your question. I think that's probably a question for our Registration and Standards Committee. So if you'd like to connect with me offline, perhaps we can have a more detailed conversation about the training and the accreditation. Certainly the CMC have a number of groups that individuals would be extremely welcome to join to further their knowledge and experience of mediation whilst in the UK, and if they're based internationally. For example, there is a community mediation working group, a peer mediation working group, and an academic forum. You'd be very interested, very welcome rather, to join those groups. I will put my email address in the chat in case you want to follow up on any of those. It would be wonderful to have your presence at those meetings.
And please, the second hand, Miroslava, please ask your
Доброго
question.
дня. В мене таке
Good
запитання.
afternoon.
Скажіть, будь ласка,
I have a question. Victoria, if you can tell me,
чи всі спори в громадах
do all
дозволено
disputes in
вирішувати за
community
участю
are
медіатора?
all
Тобто мене
disputes
цікавлять спори
in
з
communities
сімейних
allowed to be
питань. І
resolved
якщо
through
такі спори
mediation,
є,
including family
вони
disputes?
вирішуються,
Is that
то яка
possible?
частка
If
спорів
not, then
таких
what's the
спорів громади
share
займають
of
саме сімейні
disputes
спори?
resolved through mediation, and what's the share of family disputes in general, roughly?
That's so sorry, I didn't capture your name, but I did hear the question, so I'll attempt to answer it. Community mediation organisations do support family disputes. There are certain rules that if a family mediation case is going to the courts, there has to be a Family Mediation Council accredited mediator that conducts an initial mediation assessment with the parties. But if you're talking about a family mediation dispute that's, for example, a dispute between a brother and sister over the care of an elderly relative, or some other intergenerational family dispute, these are the type of family disputes that we commonly see supported in a community mediation setting and are very effective.
Я перепрошую, я хотіла
I do apologize.
запитати саме про земельні
wanted
спори,
to ask
спори у земельних питаннях, які стосуються
I
землі,
just wanted to
земельних
ask on
питань.
top of that about the land-related or property-related disputes, if this is about land, for instance.
Land dispute.
Yes, so there are circumstances where community mediation can support, for example, boundary disputes, disputes between neighbours, disputes between landlords and tenants, for example. And then there are some situations where it would be more appropriate for those disputes to be considered in a court context. But certainly some disputes involving land are disputes that could be suitable for a community mediator. It much depends on the context. So sorry, I'm not avoiding your question, but I hope that gives you some sense of the fact that it is possible and that many community mediation organisations will support those types of disputes.
Thank you, Victoria. Dear colleagues, another question will be provided at the end of our session, and you can ask all of you want. I would like to turn now to the experience of the county that we have already partially mentioned in another session today in the context of administrative disputes. I'm talking about the Netherlands. And despite the absence of specialized law on mediation in the Netherlands, mediation is effectively organized through private organization. And each of these organizations maintains its own registers, determine access, education, training standards, disciplinary procedures as part of quality control. As I know, the official website of Dutch judiciary shows that mediation plays an important role in dispute resolution. And I think that the Netherlands is a brilliant example that mediation is popular not only in society, but also supported by state authorities. And I'm glad to invite Willem Ruiterman to disclose for us the great experience of the Netherlands. Please, Willem, floor is yours.
Thank you so much, Svetlana. Very good afternoon to you all, people. Welcome to this beautiful online event. It's a great honor for me to be invited to speak to you. First of all, I want to thank the Ukrainian Mediation Academy of Mediation to give me the opportunity to give you a small presentation today. My role is to tell you something about mediation and alternative dispute resolution in the Netherlands. But first, let me tell you something about myself. I'm a mediator and chair of the board of the Dutch mediation organization, NMV. My professional journey started with 10 years in retail to 15 years in insurance and human resource management, in which I became one of the first registered financial planners in the Netherlands in 2001. The financial planning journey was relatively short-lived. I sold my company in 2004 and started a professional flying career as a contract pilot. I started as first officer and ended as a Captain 737 and Boeing 787 series. As you know, the task of a pilot is to bring people from A to B in a safe and timely manner. However, flying stretches of 15 hours with 20+ cabin crew and some 300 passengers in a small space easily lead to interesting situations. This is where my first mediation experiences were formed. But there's so much more. I've worked and lived for airlines in Turkey, India, Indonesia, China, Iceland, and the Baltic states. Therefore, I feel privileged to have the experience of so many beautiful cultures I was working with and lived in. And with that experience, I decided to become a full-time mediator by profession in 2020. Since 2023, I have the honor to lead the Dutch Mediation Association as the chair of the board. Together with my hardworking colleagues, and professional fellow board members that were guiding, Together with my hardworking and very dedicated and professional fellow board members, we are guiding our association towards an association where our members are represented to all levels within our society. An overview. Our mission is to advocate for mediation, next slide please, in all its facets to various stakeholders, including politicians, NGOs, and general public. Our work emphasizes promoting mediation as an alternative to legal procedures and support help seekers in addition to legal aid seekers. And this is very important because the legal system talks about legal aid seekers all of the time. As NMV, as mediators, we need to look further, and that's why we advocate the addition of help seekers to legal aid seekers. We're inclusive. We strive for inclusivity, welcoming professionals such as coaches, psychologists, HR managers, notaries, mayors, directors, and all that come professionally in touch with conflicts. We call them not the mediator members, but the partner members, because in the end, they take care of pointing towards mediation. Our members benefit from discounts on insurance and other benefits. Our high-quality magazine, available in both printed and digital formats. Newsletters and networking sessions. Permanent educational webinars, and more. We're organizing special events. And during the last week of October, we organized the Week of Mediation, where mediators across the Netherlands host events. This time, the Week of Mediation features a small congress and award ceremony named after the former mayor of Amsterdam, Mr. Eberhard van der Laan, who was a great promoter of mediation. Since last January, our association has established chapters for 9 specialisms and an international chapter, each with its own coordinator to address members' needs based on their specialism. Within those chapters, we organize hands-on training, webinars, network sessions, peer reviews, and more. Slide 4, please. In the Netherlands, several registers and organizations oversee and promote the practice of mediation. We have the Mediation Federation of the Netherlands, a widely recognized organization that sets standards for mediators and provides a register for qualified mediators. Their approach of mediation conducted are strictly based on facilitative mediation. We have the ADR register, an international register, and please end the slides because I see you have a different presentation. Yeah, that's the right one. Thank you so much. ADR register, an international register that includes mediators, arbiters, and other ADR professionals. The ADR register standards are allowing more freedom in the use of mediation approach. Then, of course, we have the International Mediation Institutes, an IMI, an international organization that certifies mediators based on high international standards of practice. And we have the Association of Family Lawyers and Divorce Mediators, which specializes in family mediation, particularly in divorce and custody cases. And apart from that, we have the Legal Aid Board that enhances access to the judicial system for those in need and without the financial resources to finance aid themselves. What are the developments in the Netherlands? Slide 5, please. The Netherlands has been actively promoting mediation as an alternative dispute resolution method. The initiatives to enhance the use of mediation in the Dutch legal system are diverse and include legislative measures, public awareness campaigns, training programs, and institutional support. Here are some key initiatives. First of all, legislative measures. The Dutch government has introduced various legislative measures to support mediation. The Mediation Directive 2008-52 EC was implemented in Dutch law, providing a framework for cross-border mediation. Mediation bill. In recent years, there have been proposals for a mediation bill that aims to further integrate mediation into the legal system. This bill includes provisions for the accreditation of mediators, the establishment of a register of accredited mediators, and the introduction of mandatory mediation in certain types of disputes. Court-annexed mediation. Dutch courts have increasingly incorporated mediation into their procedures. Judges can refer parties to mediation and to prove mediation, and in some cases, mediation is mandated before litigation can proceed. Public awareness and promotion. Public information campaigns. The Dutch government and mediation organizations run public information campaigns to raise awareness about the benefits of mediation. These campaigns aim to inform the public about mediation and a cost-effective, efficient, and amicable way to resolve disputes. There's promotion in schools and universities. Educational institutions are encouraged to include mediation in their curricula, promoting conflict resolution skills among students. Currently, NMV runs the following programs. We have Young NMV, where schools get access to teaching materials on topics of behavior, peer mediation, etc. NMV also stimulates the surrounding mediators to take part in presentations on schools. And we are currently working on a peer mediation competition in order to get more awareness of mediation on schools and to get the Young NMV department running with young people. As said before, we have the week of the mediation every year. NMV organizes this week of mediation where mediators run activities and presentations throughout the country to promote mediation to the public by giving presentations for free or have access to their practices for the first hour for free, and so on. And last but not least, the NMV specialist chapters where mediators peer, network and train their skills with fellow specialists. Training and accreditation as the third point of our developments. Mediator training programs. There are numerous of training programs for mediators in the Netherlands. These programs are designed to ensure that mediators have the necessary skills and knowledge to effectively facilitate dispute resolution. Accreditation and professional standards. We have an accreditation system for mediators, and thus far, ADR, MFN, IMI, and FIVAS play a key role in setting professional standards and maintaining a register of accredited mediators. And then we have the institutional support. The Legal Aid Board, which is called in Dutch Raad voor Rechtsbijstand. This organization provides resources, training and support for mediators and social lawyers to provide legal aid to people without financial access to legal aid. And of course, we have governmental support. The Dutch government supports mediation through funding and policy initiatives. It has also created an infrastructure within the legal system to facilitate mediation. Integration into the legal system as the fifth point of development. Court-referred mediation programs. Dutch courts have implemented programs where judges can refer cases to mediation. These programs have been successful in resolving disputes without the need of lengthy litigation. Mediation in family law, where there's particularly encouraged in family law disputes, including divorce and child custody cases, where maintaining relationships and reducing conflict is crucial. As an example, I would like to mention a recent initiative by the Court of Amsterdam. It's called the RAP project and stands for Richting Anders procederen, or litigate in a different direction. When lawyers decide to take advantage of the joint access option, the procedure starts by submitting a joint form on which both lawyers indicate the points of concern of contention between the parties. Unlike the traditional procedure, no documents are submitted prior to the oral hearing in principle. The judge may request documents if necessary. The goal is to hold the oral hearing within 2 weeks of receiving the application form. During the oral hearing, which is given ample time and is generally conducted in a more informal setting, parties and lawyers can discuss the points of contention with the judge. If agreement cannot be reached on certain points, the judge can make a decision during the oral hearing or as soon as possible thereafter. Referral to mediation or a uniform assistance offer is also possible. And then, of course, the technology and innovation. Online dispute resolution, ODR. We are exploring ODR in the Netherlands with the use of technology to support mediation online. Online platforms and tools are being developed to facilitate remote mediation, making it more accessible and convenient for parties. AI applications and implementations play a growing role, but as the first speaker mentioned so very beautifully, in my opinion, AI can play a role, but it's, in my opinion, only a side role. To canalize huge dossiers that come with certain type of cases. But we should never rule out the real value of mediation where people talk in person together. Then on slide 6, the research and trends. First Dutch Path to Justice study was published in 2003, and I'm talking about the WDC. This is, you can close this slides, please, because this is an old slide. So please take the last one, which is good for me. The very last one. Yeah. Okay, the first Dutch Path to Justice study was published in 2003. The study was repeated in 2009 and 2014. The current research covers the years 2015-2019. Because the Path to Justice studies are repeated every 5 years, it is possible to observe changes over time and to identify preliminary trends. Compared to the previous Dutch Path to Justice studies, the current study provides an indication that access to justice has declined, such as a decrease in the use of legal advisors and procedures, and a decrease in the share of respondents who have achieved their goal. Whether these trends are in fact indicative or less access to justice in general, or for specific groups of citizens, or for particular types of problems is difficult to say. Answering this question will require more in-depth research into the possible underlying causes of problems and the considerations of respondents. Then a study, the WODC study of June 2023 about the barriers to access to justice in the Netherlands. This study of 2023 aimed to answer the following research question. What barriers do citizens experience in accessing the law, specifically those that do not qualify for subsidized legal aid? Various types of barriers may deter citizens from taking action when they experience a judicial problem, from seeking legal aid, and from initiating extrajudicial proceedings. In this study, researchers looked at the reasons why respondents did not opt for a particular approach. Based on this, they distinguished 4 different barriers. A financial barrier related to the material costs of addressing the problem. A practical barrier related to the intangible costs, such as the time and energy required to address the system. Hesitation to act related to not knowing how to tackle the problem. And a psychological barrier, where respondents reported experiencing discomfort faith, fear, or shame. And then the third research that I wanted to mention is the follow-up research on opportunities and barriers for commercial mediation by PBM, the Platform for Business Mediation. A few key points from the discussion are positive perception, where lawyers and companies report a 75% success rate, which is a very, very good score. Familiarity breeds acceptance. We've seen it with previous speakers already. The public awareness is so important. Familiarity breeds acceptance. The need for professional mediators. Importance of addressing legal aspects. The preference for a more directive mediator. And respondents believe that mediation can be a good option even in cases of severe conflict escalation. I come to my summary and closing remarks. The last sheet, please. The evolution of mediation in the Netherlands highlights several current trends and new perspectives. Notably, the use of mediation is expanding beyond traditional areas, incorporating digital and online resolutions to increase accessibility and efficiency. The Dutch government is also exploring legislative changes, such as introducing mandatory mediation in certain cases and adopting an opt-out system to encourage mediation before litigation. A lot of work needs to be done, though. Political systems, as you are well aware of, need their time to research and implement. Governmental changes are unfortunately part of the equation. The adagium familiarity breeds acceptance needs to get wings into an active approach towards the public and stakeholders. On the upside, we see a growing awareness towards mediation, fueled by its own success. Stakeholders like the government and municipalities and local governments are turning into multiple forms of ADR due to the jammed legal systems. So the wall is turning the ship. Key trends include digital mediation, increased use of technology and online platforms for remote mediation sessions, making mediation more accessible. Professionalism, continued emphasis on training and accrediting mediators, particularly those with specialized skills in commercial mediation. Judicial support. Courts are more frequently referring cases to mediation, integrating it into the judicial process. And awareness campaigns. Efforts to raise public awareness about the benefits of mediation in all its forms through campaigns and educational initiatives. Overall, these initiatives aim to enhance the effectiveness of mediation as a conflict resolution tool, addressing both legal and emotional aspects of disputes. In conclusion, mediation in the Netherlands is evolving with a strong support from our association and governmental initiatives and others. The diversity of mediation approaches allows for tailored conflict resolution, ultimately providing a more collaborative and effective alternative to traditional legal processes, avoiding expensive costs. Thank you for your attention. I look forward to your questions and further discussion on this important topic. Thank you so much.
Thank you very much, William, for your excellent and informative presentation. It was very interesting with many valuable insights. And please, dear participants, ask your questions. If now no questions, I have one question.
Thank you.
In what
Yeah.
William, in what areas, yes, areas or sphere, in your point of view, mediation would be introduced in the Netherlands, and where it's not used at all, but in your opinion, it would be very, very helpful. Oh, and we have also one hand. No, okay, after your answer.
In the Netherlands, there is a growing distrust among citizens towards the government. And although there are extensive regulations and laws to ensure citizens have proper access to the system, a decision at the government level often leads to appeals. And with that, you are directly into a legal into a judicial role. So the process transforms the appellant into a legal aid seeker, thereby placing a significant burden on the entire legal system. To address this, the Dutch Mediation Association advocates for recognizing the term help seeker alongside legal aid seeker. The underlying idea is that every conflict starts with a request for help. And by embedding this recognition into the system, mediation can be introduced at a much earlier stage, in a much earlier stage of the escalation ladder. This approach not only helps all parties involved to regain trust in the system, but also helps in preventing the legal system from becoming overloaded.
Thank you so much. And please, Tina Jones, your question. Okay, next question from Philippe Corsano, please.
Hello, thank you for a really great, amazing conference and very instructive. Now, I'm not sure if can I ask a question to all of you, or do I have to wait at the end? To all the panel, or should I just ask William the question?
I think it will be better at the end of it's a question for all of our speakers.
So I'll wait for the end then, shall I? Okay.
I think it will be better because we have also one presentation, and afterward will have a possibility to ask questions for our speakers, not only you, actually. Maybe Ms. Jones try to ask your questions, and I don't know.
I can wait so that I don't want to interrupt the program. So I'll wait till every presentation. Thank you.
Okay, thank you so much. And dear colleagues, I would like to invite you to take a shorter trip, as we can afford it, to another continent, to Brazil, and to get know with another scenario of development of IDR system. Brazil is a country in which IDR and mediation in particular have their own very interesting path of development due to various factors, including certain features of Brazilian judicial system, the peculiarities of culture of resolving all disputes in court, and as a result, the total overload of courts. And IDR is precisely the lifeline, the guideline that will change with current state of affairs, which has proven to be ineffective. And I'm pleased to give the floor to Luciana Drimel, who will not only share the Brazilian scenario of IDR development, but also propose strategies for its effective development. Please, Luciana.
Right. Thank you very much, Svetlana.
you have made quite a wonderful resume of my presentation. And first of all, I'd like to say that I'm really pleased to be here among all those distinguished panelists and some friends and people who brought a lot of interesting insights for our studies and the development of the mediation worldwide. But first, I'd like to really thank my dear friends, Luisa and Svetlana, that we've been together 2 weeks ago, and it's very important to gather people all over the world to think about mediation. So thank you very much for the invitation. Thank you for all the panelists, and thank you especially also for the audience, that I know that it's an international audience, but I'd like to address especially to the Ukrainian community, because I want to send a warm greetings to our Ukrainian brothers. I don't know if you are aware, but we have here the largest community of Ukrainians in Latin America. It's estimated between 500,000 and 600,000 Ukrainians and their descendants in Brazil. The majority in my state of Paraná. That's why we have this special bond to this country and to this culture. So we really want to say that we are very sensitive and supportive to the Ukrainian people and all your difficulties. So again, thank you very much for all of you. And I will start to share my presentation that, as Svetlana said, talks about not only about our scenario in Brazil, but also I will talk about some possible strategies, just like my colleagues have done. I'm just trying to, well, no. Just a second, let me okay, now it is. I'd like also to make some comments about my colleagues, about the trends that Professor Marilu has brought, the importance of the joint sessions that I truly believe, Professor Marilu, and all the other trends that she brought, especially AI and the possibilities and the dangers of the AI. And also my friend Imad that talked about mandatory mediation, which I think it's a very important topic to be discussed, because we know that some countries, because of this mandatory mediation, they have a huge development of mediation in their environment. And Professor Victoria that talked about the difficulties, but also the possibilities of mediation in UK, that I truly, I can say that some of, or most of the difficulties we do have in Brazil. And Professor Wilhelm that talked about so many interesting initiatives and topics that we have to go for to develop mediation in our countries, just like digital mediation, professionalism, judicial supports, awareness, public awareness, educational initiatives. And I'm talking about AI, the side of the AI. I'm talking about this because some of that I will touch in my presentation. So thank you very much for all your important insights. So I'd like to start talking about if you want to somehow make contact with me, please feel free to do it. and my experience in law and mediation is about 30 years in law and 12 years in mediation. And I can say that I have made a switch in my career, because I used to teach, for example, civil procedure. And once I said, no, it's not satisfying me anymore, and I want to go further in my contribution for people. So I used to say that I dated with arbitration, but I married with mediation, because mediation has really touched me since the very beginning, that I could understand and study more mediation. So this is a little bit of my trajectory that I wanted to share with you. And I want to start with a provocation. The provocation is how we see the world. How do you see the world? And normally we see in eyes of very standard possibilities. For example, in my country, I can say that the standard is to talk about football, slums, carnival, but do we really are resumed in those moments of our countries? So I'd like to invite you to look beyond obvious. And this is for us, but for all countries. Sometimes we are a little bit stigmatized, and I'd like to invite you to look beyond obvious in all the possibilities that we can, especially here in the studies of mediation. So one thing that I think it's very important is to understand about the global competences and to understand the dispute resolutions in a globalized world. Recently, as I said, we've been together in Vienna, Svetlana, Luisa, and some other colleagues from all over the world. And also we've been together in Paris in February. It gives me the dimension of the importance of globalization in every of our activities, but also in mediation, in ADR, much bigger, in a much bigger scenario. So knowing and understanding the diverse cultures and diverse structures and legislations, so it brought me a lot of insights. So I got very I can say that I have totally another possibilities in my life after those two important experiences in global mediation. So I think we should think globally, but act locally. And that's what I am trying to practice. And talking about trends, we cannot forget the Global Pound Conference of Singapore in 2016 that brought us some directions for the trends in mediation for the next 10 years or the next generations of mediation or ADR. So efficiency and cost effectiveness, party control, improved and restored relationships, advice from councils, and guidance from dispute resolution providers, educational programs. And the most effective approaches may rely on multiple processes that goes beyond just mediation and includes arbitration, includes negotiation, includes ombudsman, includes dispute boards, and so on. Pre-dispute or pre-escalation processes, collaboration, and conflict prevention are emerging trends in managing commercial conflicts, and governments and ministries of justice have the greatest potential to influence changes. Why am I bringing this? Because most of our colleagues today, we talked about this. We talked about all those trends that are in bigger or less sizes, they are happening in their countries. So let's talk about a little bit about my reality here in Brazil. We really have a problem in our market regarding ADR. Svetlana said that we have a market which is, I would say, awakening, but we still have a lot of troubles here. I would say that we have to consider judiciary costs, the number of the lawyers, the increase of litigation, and the main litigators in Brazil are banks, institution, public administration, and telecom services. So we have this scenario that is very chaotic, and I will show you some numbers and you will understand better what I'm saying. So what we can foresee, we are trying to enable democratic access to dispute resolution and to private services to promote the connection between consumers and investors and providers of ADR. Improving networking, collaboration, ethical behavior, co-responsibility, co-creation, education, diversity, and sustainability. That's our goals. We have, unfortunately, a scenario. This is, we can talk about our paradigm of the judiciary, which is not so good. We can say that in 2023, why am I talking about 23? Because we have a report. Every year we have a report, and the report regards the last year always. So the last report that we have, the report of 2024, talks about the reality in 2023. So we have here the cost of judiciary is very huge, about $24 billion a year. And the taxes just support 10% of this cost. This cost, it means that 90% of the cost is paid by the citizens. And the cost means 1.3% of our GNP. And it increases, the last year, the cost increased in 9%. It's a lot. And we are overloaded with more than 83.8 million lawsuits. These are our last data. This is something that we can imagine how we get there. But unfortunately, I have to say that we are getting used to it. Something that we could never do is get used to it, but we are getting used to see this scenario and think it's everything okay. But okay, let's talk about how can we improve this scenario. So we have a legislative scenario, as Professor Wilhelm was talking also about in Netherlands. We have a lot of laws that were enabled in the last 30 years. We started in 1984 in small claim courts, and then special courts, and then the arbitration law, the judiciary restructuration, the development of the consensual system in Brazilian judiciary, the civil procedure code. When Emad was talking about the mandatory mediation, we do have also, Emad, a mandatory mediation, but you could say it isn't good in Brazil. No, because we addressed all those mediation cases to court annexes who are not prepared, who used to make mediation sessions in 15 minutes. So, of course, we cannot go in a very good scenario with a mediation session, quotes, in 15 minutes. And that's why we have to improve, especially addressing to the private market. That's our main concern here, to address the cases, the mediation cases to the private market. And we do have a mediation law enabled in the same year of the civil, the changes of the Civil Procedure Code, and also the changes in arbitration law. And now, currently, we have a lot of statute laws projects and also laws that were enabled that are indicating mediation as the first solution for the cases. Unfortunately, we have this population of lawyers of 1.5 million lawyers in Brazil, and in 15 years, we will be 2 million lawyers. It's something about one lawyer for each 164 inhabitants. And this data is very impressive too, because we have here in Brazil 9,600 law schools, and worldwide there are less than 102,000 law schools. That's why we have this data here. And those lawyers are not being prepared for non-litigative methods. That's the point. So when Professor Wilhelm talks about education, yes, Professor, I truly believe in that, because I've been teaching in university for 24 years. And I truly believe in education for the next generations. And that's why I used to participate in international competitions, because I believe that that's the future. So what are the actual solutions in Brazil? It may be you can find some similarities with your countries. So we can say that the judiciary used to increase the judicial consensual centers, the court annex, but the court annex, they are not so prepared to take care of the cases, because we don't have a lot of professionalism, as said Professor Wilhelm, because most of the mediators are voluntary, and some of them are not prepared. They didn't do appropriate trainings in mediation. So we have a lot of judicial centers, but they don't deliver a very good service in mediation. The solution given by the private sector is trying to provide mediation training courses. So we used to say that we have more training courses than mediation sessions in private sector. So we are in the phase in Brazil that we are having a lot of training courses. Not all of them are in a good quality, but some of them are. But yeah, this is a beginning. And the other solution is to provide private providers of ADR. We have some of them. We have good providers, but we don't have a healthy or a wealthy market for private providers of ADR, because all the demand is in the judiciary and the court annex. That's the point. And then why we must change this scenario, because the market is degraded. Brazil needs to take a position towards international investment in ADR, because we don't have it, because we don't have a lot of credibility in this area. Universities are losing their law students because after the certification, the graduation, they don't have a wealthy market to work on because we have a lot of litigation, and the society, people don't have any other alternatives than wait for 10 years for a judicial award. So the solutions are not working because the market has to be more mature for those solutions. The market has to rely on multiple processes and not just looking at the judicial solutions. And the ADR market needs to be more collaborative and work on conflict prevention. So yes, believe it or not, the ADR market is not so collaborative. I don't know in our countries, but that's our reality here. How we could make the methods, ADR methods, more economically sustainable. So some strategies, some of them you, my colleagues touched on those topics, those issues. So increasing awareness and education. So we really believe in that. Streamlining processes, simplify and standardize ADR procedures to reduce time and costs. Use the AI platforms. And I think, yes, has to be some side role, but we have to use them to simplify, standardize the procedures. I think AI has this important role. Government and institution support, yes. We think the government has to support those initiatives because it's also important for them, especially here, for example, in Brazil, with this huge amount of lawsuits. So it's very important to let also to the private market to take care of those cases, of the litigation. Building a strong ADR ecosystem, networking, and trained and accredited ADR professionals as what we are doing here. This is very important for us because we have to spread those lessons to our countries. Cost transparency and predictability. Establish clear and predictable fee structures to enhance trust and make ADR costs more manageable. Yes, we have to maybe try to find patterns to costs and mediation. Promote efficiency and effectiveness. Utilize technology to improve the efficiency of ADR processes. I have touched in this point also. Encouraging early resolution. So try to use more effectively multiple processes, just like early neutral evaluation, or even arbitration, non-binding arbitration, things that we can try to predict the future of that case. And improving accessibility, ensure ADR services are accessible to all social economic groups by providing affordable options and pro bono services where needed. So yes, we can bring all people to know and to use those ADR methods. These are some topics that can be discussed, maybe not in this gathering, but in future ones. But I think it's important to put them on the table to understand that we have to discuss more, to try to understand the different cultures, but also that we have different cultures, but in the same, at the end, we are all the same, with difficulties and improvements. And talking about law professionals, we should prepare more our law professionals for the 4.0 market with self-composition skills, collaborative posture, new vision of conflict, and social pacification, negotiation skills, and the lawyer as a person who decides the resolution method. So the counsel, the advisor of the method, and the role of the bar associations to promote and decrease the class resistance, because we know that the lawyers, we have a lot of resistance to mediation. I don't know why. I don't know, people do not has this sensibility that we are just trying to decrease the huge number of lawsuits, that everybody will be in a better position if we decrease this number of lawsuits. Encourage collaboration, ethical behavior, diversity, and sustainability. Promote discussions about the ADR market, and promote discussions about the incomes in the ADR market. I think one important point of the resistance of the class of the lawyers is because lawyers think they will lose their incomes if we have the figure, the role of the mediator, which is not true, but it comes from the lack of awareness of the role of the mediator, and that's why we have to improve it. The importance of soft skills that we all know, and where to go. So some possibilities here: education to change mindset with awareness and action. Once we have this education and this awareness, we have to act. Programs, technology, advisory. So this is some suggestions and some of possibilities that we can go through to make it happen all over the world, worldwide, I would say. So the last thing is, we are diverse, but and all the same, because our problems either are diverse, but also the same. So we have to think globally and act locally. That's my contribution, and I'm willing to hear from you any kind of questions or suggestions or critics or whatever you can contribute. Thank you very much again, Svetlana, and thank you very much also, Luisa, and all my colleagues for this important moment of our gathering worldwide to reinforce that we are a global community and we have to think globally. Thank you very much.
Thank you so much, bravo, Luciana. Very charming presentation. You have drawn all participants' attention to important aspects of IDR and mediation. And actually, finally, we reach the QA session. Please don't hesitate to ask questions, share your thoughts. I remember we have, yes, 2 raised hands and some questions in the chat. Please, I see a hand from Philip Corsano.
Thank you. So the question is, as the panel has very eloquently established, that there is a multiple issues here in the way that we adopt ADR. The first, I think, very significant one was the level of distrust of the general population in terms of their interactions with the state. And given Mary Lou's very interesting observations about the way in which we conduct mediation, and how we essentially have gone to shrink it to fit a sort of cookie cutter approach, if I think is what you were saying, to meet the time constraints. The question is that if we were to establish some sort of wider ways in which we could mediate not within these very, very short time constraints, that we could establish maybe periods in which you could go back into mediation and not just treat it as a one shot. And perhaps Victoria as well, if you could sort of address the way in which community mediation is it a single shot or is it a more of a continuum? And with respect to the other speakers, the same issue in terms of would this increase the success rate of mediation, which at the end of the day is what drives the industry. Thank you.
I want to clarify the first question was for Mary Lou, yes, and the second for Victoria. Is I correct to understand?
Actually, anyone can answer, but yes, thank you very much, Svetlana.
Thank you.
Thank you, Philip. Well, I will begin and try to offer something. You ask a really good question. All the questions have been good today. I wish I could say that there would be a prescriptive thing that we could put out there to say all mediation should be this long or that we should all offer this much time. But I think that would be, as you know, would be very difficult to do. I do hope that we get to a point where we say it is important in mediation to bring the parties together, to let them see each other and talk with each other, because that's what mediation was developed to do and what it does best. And I would hope that we know from the research that all mediators have got training about how to work with people who are working together. The problem is because of time and wanting to make more money quicker, people are thinking, well, what I can do is just never meet with them and just kind of do some shuttle negotiation and call that mediation and be done and collect my fee. What we do is we lose the essence of that opportunity to bring people together. And I would say one thing, it's not just helping this conflict, because what I found is that when people have an opportunity to go through a mediation, they say they learn something about listening to another person. So in other words, they take something with them from the mediation, some skills they can use in other conflicts. And we live in a world today where we need more people who have those skills. So those would be my comments, but thank you so much for your question.
Yeah, maybe I could elaborate a little bit on Philip's question. The level of distrust I hear and the interaction with the state or the government. I think there is multiple variables to put into this equation. One hand, you could argue about legislation, lawmaking, but there's also a matter of how we as a society evolve. And that's one of the main topics, our main concerns within our country here is to not only start to sell mediation to the big public, but not without also putting into the place the kids, the children, the students. Everybody needs to be involved, because in the end, conflict, being able to manage your conflicts is something that is with us every day. It's part of human being, of everyday life. But the way you manage it makes that it is going to court or just having a conversation. The way you manage it also says a lot about how it is escalated and how it needs to be approached, or what intervention to use to be able to manage. And Mary Lou, you say it's so right, in my opinion. If you want to open yourself up to ADR, you open yourself up to a path that leads you in a different direction than aggression or being mad or just being short-sighted or whatsoever. So I think this is a very complex but also delicate, and with that a very, very interesting way of looking to how we should manage and how we should deal with problems in wherever you are in this world, because in the end, we are the same. We are the same species. We are humans, and we need to address the problems that we face every day with each other. And so I think to just come back a little bit to the question of Philip, I think it is very, very important to see our way of dealing with problems in a line parallel to healthcare. If you have a labor problem, an employee and an employer have a problem with each other, in most of the cases, this problem does not originate from the company or the organization that you work with, but the problem originates from a home situation. And so by seeing that and addressing that, you could also make this parallel with healthcare. And with that, you could argue that there needs to be unlimited funds to address ADR into the system. The reality is that that works very slow or not with our governments. So the local initiatives, and we call that buurtbemiddeling. It is the ADR forum where two neighbors are addressed for their problems with just not a mediator, but somebody who gets a basic training in conflict management. This is where it all starts. And so as NMV, we try to make that bigger. We try to enhance that. We try to make contact with those groups because they help us to familiarize mediation into the society. Thank you.
And Philip, just to come back to you briefly, like you, I picked up on Willem's point about a level of distrust in interactions with the state in the Netherlands, and your comment about mediation processes perhaps being shorter than we might like. And I think it comes down to education, because if individuals know what mediation is and how it works, then they can approach it with that knowledge and be able to engage more effectively. And in fact, there's a report by, I think it was around in the time of Her Majesty's Courts and Tribunals Service. They did a report on individuals who knew about mediation versus those who didn't know about it. And it was really fascinating to look at the outcomes of the mediations, far more positive for those who had an understanding of what mediation was. They were ready to engage. The other thing about education is, I think there's a key message that needs to come through, which is relevant to the question about interactions with the state. Mediation is very empowering to individuals. And that's a message that we need to get across to the general public. You know, it reduces state intervention in the sense that you're not having an outcome imposed, and individuals can create the outcome in a creative way. And it's not the easy option. People need to know that as well, but they need to be prepared for it and understand what it is. So I think a lot of it comes down to education. I hope that's helpful.
If I may jump in with just a few words in response to Philip and to comment on Victoria and my colleagues here, I think three things that we can bear in our mind. Firstly, it is not the legislation that can shape the world of mediation. In some jurisdictions, there is no single legislation. However, the community is efficient, cooperative, and the settlement rate is excellent in these jurisdictions and although there is no legislation. That's a very important point, because in some policymakers, they think once you have legislation, everything will be fine. But this is just a piece of the edifice. The pillars, the complete pillars should be integrated with other things that my friend Luciana added, that we should look beyond the obvious. We should think globally and bring the other pillars of the edifice of mediation or the ecosystem of mediation. And that's why, like countries like Singapore and other similar jurisdictions, they think of mediation as a profit center rather than a cost center, because the hidden causes of litigations, of diseases, of interruptions in the communities, of the relationships, so many things, I'm sure we are all aware. That's why mediation is a profit center, because it takes the community into better standard of living, better peaceful situations, better acknowledgement of recognitions of success, better ranking and everything. That's very important. And it seems to me this perception is not well defined in some policymakers, because the word alternative dispute resolution, it is not alternative. It is an essential, fundamental, and a key process now, especially post-COVID-19. That's the first point. The second point, I can't agree more with Victoria. Education, 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 and education should be part of the DNA. And I'm so pleased yesterday when I heard from Louisa and our colleagues in Ukraine that there are materials for the secondary schools, for the postgraduate, for the masters. By education, that will be an integral part of the DNA. The third point, as an arbitrator, and every day we have hearings, we have this. In so many cases, the parties just need to be heard, but we are not optimizing the momentum of this being heard. So the legislators should think how to bridging the gap between litigation and mediation, arbitration and mediation. In Singapore, because being part of my practice, there are this protocol between ARB, mid-ARB, and in the International Commercial Court, there are also some approaches. I think in our different jurisdictions, we should accommodate mediation as a persona grata, not persona non grata by our colleagues of lawyers or counsels. And I would say that alternative is no longer alternative. It has come to stay, and it should be an independent pillar that will shape the future of our life, especially with so many changes that are happening, with wars, with peace, with everything. Mediation is the iconic pillar that can fit for what we need. I don't want to elaborate more, but that's what just clicked my mind with my distinguished colleagues in this panel. Thank you.
I think my colleagues have talked and said everything I wanted to say. I just have one question, one provocation for we all. Why mediation and those not alternatives, like Imad said, methods are so difficult to be understood or accepted for people? When we take contact with those methods, it's immediately we recognize the importance and the efficiency of those methods. Why people in large scale don't see it? Sometimes I ask myself, because when we see this international gathering and everybody is kind of saying the same difficulties, I keep asking myself, and I leave this provocation for you guys, why people don't see what we see. But that's fine, it's just a provocation.
Okay, thank you for your answers. And we have next question from, I am afraid to incorrect to say the name, Suela Sulkaya. Please ask your question. Miss Suela. Okay. Andrei Vasilishin, please ask your question. Maybe something wrong.
Вітаю, я Андрій
Good
Василишин.
afternoon, good evening. My name is Andrei
Автор
Vasilishin.
візіонер концепції Goodwill
I'm the author of Could You Planet concept paper.
Планета доброї волі.
This is about the goodwill planet that I'm writing about, that requires arbitration on a planetary level. I want to thank all the organizers of this forum for everything that you've done, because we can hear people from so many different continents, and this is brilliant, because the thing that I work with, I can now rely on so many different opinions. And now I can see that on so many different continents, I'm showing you the globe, we have an alternative to arbitration solution. There should be a person who provides an opportunity to others to lose the situation or play the situation. Think globally and act locally. I would add to this one. Mobility, search, and know. Look for something unknown. Look for those mediators who advocate mediation, who develop competencies from so many different countries. But is it worth combining this effort and try to be aligned with so big diversity among mediation professionals? Will that be supported if we attempt to align everything? Was this a comment from your side, or this was a question? This is my reflection and a question, whether it is a good solution to consider this as an alternative. I have one development that allows delegating everything out.
Це питання для всіх спікерів, так?
Ну, дивіться, зараз ми говоримо про
I'm going to
компетенції
explain.
з
We are
різних
talking
країн,
about
і
competencies
вони
that
є
exist in
свідченням
different
факту, так,
countries.
як є.
And this is an evidence of
Образу
diversity of
бачення,
opinions.
що це було
But
одним
how
концептом,
about
який
making
би
this a
опирався на
one-stop
концепцію
solution,
бачення
an aligned
планети
one
доброї волі?
that would
Немає. Тому я
generate
пропоную
like a
цей
goodwill
метод
planet
будемо
vision? So I'm offering this as an alternative. Would you support something like this so that we build a common vision that is shared pretty much everywhere in the world?
Okay, dear speakers, do you have some reflections or answers on the questions of our participant on the resolution? Or maybe it's very complicated question and we need the time to thinking about it and give the answer later.
Well, Andrea, I haven't read your book, and I think it would be useful to do so for sort of commenting, but just in a very general comment, I think greater collaboration was always to be welcomed. And I think what I'm hearing from the conference is actually a lot of similar approaches and similar thinking. And it's events like these that enable us to build on that collaboration. So just a general comment from me from now.
If I may add just on that point of how one-stop solutions the participants noted out, there are two good news. In my capacity as an arbitrator, the number of settlement agreements during the arbitration proceedings have been an increase. And in my practice, out of almost 10 arbitration cases, there is almost at least one single case that the parties decided amicably to reach a settlement agreement, and instead of issuing arbitral award, there is the consent award, which means the awareness of the parties is almost into mediation or always to find a way out of litigation and arbitration. That's the first good news. The second good news, there are some initiatives worldwide in which during any proceedings of litigation or arbitration, the parties can resort and they can go for mediation. And this is increasingly in Singapore, in China, and in other jurisdictions, in order to encourage the parties, regardless their contractual obligations, regardless their dispute, to try mediation. And this is an increase, which means we need to exert more efforts in order to encourage the parties. And I would strongly advise you to read the survey of Singapore International Dispute Resolution Academy, CIDRA 2020, and the same survey for 2022. And there is another survey that will be issued in 3 weeks from now about the tendency of in-house lawyers and of the parties towards mediation in their cases. So the future is giving us an optimistic perception that mediation will dominate and will come to stay. Thank you.
Thank you so much. Please, next question, Miss Olena.
Добрий день. Щиро дякую
Good
за
afternoon, good evening.
такий форум.
Let me
за
thank you so
цікаву
much for this
інформацію.
fabulous
Було
forum
дійсно
and for
неперевершено.
brilliant information. It was just
Єдине
incredible.
одне таке маленьке запитання
I have
залишилось.
just a small
Аналогічне
question.
запитання, дуже схоже, вже
It's a very
задавалося.
similar one to the one that
Еммат
have already been
Хусейн,
asked.
наприклад, говорив,
Ahmed
що
Hussein, for
у
instance,
них є
mentioned that
медіація обов'язкова.
there in
Крім
some of the
того,
jurisdictions there is
Вільям Рютерман
mandatory
теж говорив, що в Нідерландах
mediation.
теж
And
в
William
деяких
Reuterman
категоріях,
also mentioned that
я
it's for
розумію,
some of the
теж буде
disputes, for some of the
вводитися,
categories,
введена
they're
обов'язкова
about or
медіація.
have already
І у мене запитання,
implemented
медіація
mandatory
це взагалі
mediation.
принцип
And I have a question.
добровільності.
Mediation
Як в
has
такому випадку
a
іде
voluntary principle
співвідношення? Чи
behind
не
it.
порушується
So
в
how we
даному
balance
випадку
that?
головний
Do we
принцип
not
добровільності?
disrupt this
Оскільки
voluntarity?
медіація
Because
це коли люди
mediation is when people are willing to, both parties are willing, or several parties are willing to go for amicable or alternative resolution. But if this is mandatory, then maybe it's not mediation anymore, but something else. What do you think about it?
I could have a comment on that, if you allow me. In the Netherlands, it is not mandatory in that way that mediation needs to be fulfilled at all costs. It is what we call a proof. So you try mediation, and it does not set aside the right of every citizen in the Netherlands to go to court if he pleases or if he thinks the mediation is not going to succeed. So there's freedom in mediation. There's not freedom in just to try the first session. And if you do not succeed in the first session and you decide to bail out, then you can just continue with your legal process. So that to answer your question from my side, yeah.
Also to add here, or to build on William, two things. It depends on the maturity of the communities. In case of Saudi Arabia and United Arab Emirates, the policymakers found that because of the litigious or of the litigation mindset and the newly introduced mechanism of mediation, they found that mandatory mediations, and as noted by William, it is mandatory to join, but not mandatory to be forced to reach to a settlement agreement. They found that this could be an indirect way of promoting, raising the awareness, get them in, at least to get them into what's meant by mediation, what's meant by caucusing, what's meant by reaching settlement. So that is one of the rationale behind the mandatory mediation. And that's why there is no sanctions, there is no, penalties in case if the parties didn't show. That is one point. The other consideration here, how to do the balance between both, it depends on the level of maturity, but it's a very debatable issue how to do the balance. The balance is very simple from my own point, that you are not forced to reach to the settlement, but you need to come to show up and to believe that there could be a way to release and decrease the load of the court. So it is a judiciary approach to find a way and access to justice via a new approach, or this is part of what we call multi-doors justice. But still, it depends on the community maturity and the practice of mediation. In some jurisdictions, the practice dates back 100 years, but in some, especially the civil law-based countries, still they do believe in litigation being the only door for justice. So you need to have a transnational form or transnational period in order to integrate this new baby into the family of justice, and that is the reason for mandatory mediation.
If I might just add briefly to that, I'm really interested in our use of language around this, and obviously in a community context, we talk about mediation being voluntary, and that's something that is very important to a lot of people. I was always aware that some cases would be referred, for example, by police officers or by social workers, and with those referrals, I wondered the extent to which the parties were truly there in a voluntary nature, or whether in fact they did feel a degree of compulsion to take part. So once again, and at risk of sounding like a broken record, I think so much of this comes down to education. It's about inspiring people to want to take part in mediation. And as far as automatic referral to mediation within the civil justice system, as Imad has said, there is no requirement to settle. There are many aspects of civil justice systems that are compulsory, for example, exchanging witness statements and lists of documents, and if you're a defendant or a respondent to a claim, you're certainly not there voluntarily, but actually there is no requirement to settle. So I grappled with this issue for a very long time. But I'm of the opinion that actually it can be helpful to individuals, and I think it would be more helpful if we could do more education to encourage people to want to mediate.
Thank you. And please, our next next question, Miroslava.
Thank you so much for all the presentations and interventions today. They were fabulous, very interesting and useful. And I honestly hope that our nation will be developing mediation in the future as well and borrow the best possible practices internationally that we discussed today. I have a question of a practical nature. I understand all our esteemed speakers, they're practitioners as mediators, but please, what do you think, from your own opinion, would all disputes, could all the disputes be resolved through mediation? If not, then what would be the traces or distinctive features in a dispute that would tell you that that's the one that can be resolved through mediation? And what are the traces of those which obviously cannot? Thank you.
Питання до кого? До всіх спікерів, так?
Is this the question to all the speakers?
That's a very interesting question. If you allow me to just give you an example from my practice. In one of my mediation cases, just to talk practically, while I'm doing the pre-mediation homework, as you know, the beauty of mediation is that you can meet each party individually even before you start the mediation process. That's what we call pre-mediation. During the pre-mediation in this case, I found that one of the parts didn't want to meet me, and he just sent the delegated the counsel to act on his behalf. And this is a signal that the party in this case, it's just a signal that the party in this case is heading into litigation, not mediation. That is one of the parameters or the criteria. The second one, during the process, while you are moving from exploring into bargaining, into negotiations, into conclusions, you have to make sure that if any of the parties start denying what has been discussed during the previous sessions, previous meetings, this is another indicator that the party is absent, or is present but absent. They have just come to do the tick for mediation. Thirdly, it depends if the council, in-house council mindset to make his own interest or her own interest much higher than the interest of the party. This is another criteria that there is a dangerous process ahead of you. And in case also if the parties have been stayed at the court for longer time and there are hidden issues, because in mediation you need to go to the root cause, not rather the highest part of the iceberg. You need to dig into and to know the root causes. If you found that they are just taking this voyage of mediation to fulfill other targets, you should realize that there is no settlement agreements that you can reach. Of course, there are other criteria my colleagues can add, but these are the things that I have faced in my practice. But the most important one during the pre-mediation, which I am always calling it, it is like the MRI. When you do the X-ray for before you go to the physician, this MRI can give you some signals that you have to be cautious that you may not reach or the parties may not be able to reach to settlement. Of course, there are other considerations, but I'm just clicking this from the practice of mine in mediation.
I'd like to very briefly add to the very important considerations of Imad. I totally agree with him, but I also could say that mediation of process of dialogue, it fits in every kind of case, because even though you feel that the path is not the mediation itself, the procedure of mediation, the process of mediation, this pre-mediation that Imad talks about is very important, because this first dialogue can show parties where are, or give them the direction where is the real interest of the parties. So it will be very important if you go through the process of mediation or not, because this first dialogue, this first conversation, this first gathering will show parties a best direction for the solution. So always we'll have space for pre-mediation and also sometimes mediation itself as a process. So yes, mediation is it fits every time, and then you can go to other processes. This is my opinion about my practice, because the pre-mediation, this first conversation, is very important for parties.
I would like to put one comment on this, and that some cases are simply not suitable for mediation. Let's say that you have a case where you want to test the law, if the quality of the law applied is good or not. Then you go to court and you let the court or the higher court decide on that, and it's not suitable for mediation. But many cases are, of course. And what we try to advocate in the Netherlands is that in every cooperation between an employer and an employee, or between parties in business, or organizations. Put in your agreement, in your MOU, in your intention, whatever, put a mediation clause in and define in that mediation clause what the circumstances are and will be where you start to have at least one conversation with the mediator to see if you can solve your problems in an amicable way.
Дорогі друзі, мені здається, ми
Dear
трішки
friends, it seems to me we're a little bit late and we abuse our time, especially the time of our speakers, despite they're so happy and ready to be answering many of your questions. We're too late in terms of time. It's already been 45 minutes past. So I think let's have one more question, and then the other questions will be answered in writing. You can write back to all our speakers. They have left their credentials and contact information. I can see so many raised hands. It's like a big forest of hands, but we do not have that right, and I cannot dare to abuse the time so long. Let us answer one more question, and then we're going to adjourn the meeting.
У спілкування в кулуарах, як так кажуть.
Then we're going to do the networking discussions, each and everyone in his and her place. Okay, let's go ahead.
I remember Vesna Svetanovska, you have a hand.
Yes,
And
so first of all, I would like to thank you for providing us with the opportunity to be part of such a beautiful and great and productive presentations and discussions today, especially nowadays when mediation is more than needed worldwide, with a specific accent, of course, to the issue between Russia and Ukraine, also Israel and Palestine, but also Serbia and Kosovo. But also there is a problem between my country, North Macedonia, with the name issues with Greece and the nation issues with Bulgaria. So I have a question to whoever may respond. Do you think that the mediation of today is strong enough to make a contribution towards the solution of these problems?
Absolutely.
I would agree. I would totally agree. I think, but it's going to take, you know, people being willing, and I think the United Nations needs to step up and help. They're very much pro-mediation, and I know that they have people that go out and help, but making certain that we get individuals into these areas and get buy-in from both sides so that we can have that dialogue. It's been very challenging. There have been a lot of things that have made that process very difficult. I know between Ukraine and Russia, but also in the Middle East and in other conflicts you mentioned. But yes, I think it definitely, and we've got history that shows that it can be effective. And we just need to be persistent.
Dear speakers, dear participants, thank you. Thank you so much for sharing your expertise, your inspiration. It's so valuable for each participant. Each participant takes something different, something important to them that improve his knowledges and skills. And we're extremely grateful for your contribution. And I'm convinced that the most important value is people, a community of like-minded people who support each other, support world, and make a little bit brighter, a little bit better. And thank you so much for joining us today, for your time, for your experience. And I want to give a floor, Louisa.
Так, дякую. Я теж хочу
Thank you
приєднатися
so
до
much. I
своїх
want to join to every single word of gratitude of the colleague of mine, to all the speakers, to Mary Lou, to Emma, Luciana, Victoria, William, everybody. And the most important thing that I wanted to tell,
Світлану, яка
I'd
модерувала
like to express my words of gratitude to Svetlana because she's moderated this session. Nobody introduced her beforehand, but this is not only
співдумець, я не знаю, як
a
сказати,
like-minded professional and a colleague of mine,
натхненник,
but also
в
this
тому
is a
числі
great
того, що зараз
inspirer
взагалі завжди
of what
відбувається
we're
в
discussing
Українській
today
академії
and what's been
медіації.
going on
Пані
in the
Світлана
Ukraine's
є
Mediation
адвокатом,
Academy.
пані Світлана є медіатором,
Svetlana is a
вона
lawyer
також
and a
очолює
mediator, and of course
юридичне
she's in
бюро
charge of the
Сергіївних. Це адвокатське об'єднання,
legal bureau.
насправді,
This is a law
яке
firm
сьогодні так само ми
which
відзначили подякою. Пані Світлана навіть
also
не
was
знала про це.
recognized today with our
Подякою,
award. So thank you
Українській
very much,
академії
Svetlana.
медіації відзнак
And we want to thank you on behalf of the
медіації,
Ukrainian
медіації.
Mediation Academy.
Ось саме
You are our
своєю
great
роботою пані
partner,
Світлана,
and thank you for your contribution.
її
Everything you do,
адвокатському
Svetlana,
об'єднанні докладає зусиль для того,
in
щоб ось включати ці медіаційні
has
застереження,
a
ось
lot of
докладати зусиль, щоб
importance for
клієнти
us.
вирішували конфлікти
You
шляхом
invested so
безпечних
much
медіацій,
effort into
успішних
amicable
медіацій.
conflict resolution and
Дуже
ADR. So
Я
we want to
рада,
thank you
що
so
в
much.
мене не тільки
I'm
така
so
колега
grateful
є,
that
а ще
I not
є
only have a colleague of mine, but also a
Ми
great
вже
friend of
давно
mine
вийшли
in
за
your
межі
face, because
таких
we've
робочих
gone
стосунків.
beyond working
Я хочу за
relationships
це
only
щиро
so long
подякувати
ago,
пані
for which I want to
Світлані.
thank you very much,
А ще
Svetlana.
я хочу знову
And
ж таки
also, I'd like to
подякувати
once
нашим
again express my
неймовірним
gratitude to
перекладачам. Будь
our
ласка, я
fabulous
вас прошу навіть
interpreters who
увімкнути
massacred
камери для
this
того,
entire
щоб всі
translation.
бачили,
So please
змогли
turn on your
побачити
cameras
вас, будь
so
ласка, тому
everybody
що
can see
в
you,
чаті було постійно
because in the
багато
chat
слів
we
вдячності
had a
саме
lot
до
of
вас.
words of gratitude to
І я
you.
зараз ще попрошу не від'єднуватися, щоб ми
Sorry, my
зробили
camera is
спільне
not working.
фото. Ось
That's
такий
all
наш
right.
такий чудовий спосіб, щоб
Never mind.
сьогодні його
We're just trying to do a family
перегляд.
picture again. We have managed to actually
Більше
do it today. I can
Добре,
see you
давайте
no
зробимо такі
longer.
фото.
Okay, I'm gonna try it again whether the
Поки
camera works now or
зараз
not.
буде відбуватися фото,
And
нагадую,
while we are
що
taking the
перед
pictures,
тим,
I want to
як
remind
вас
you that
сфотографувати,
before
вас запитають
you are
вашого
being
дозволу,
taken a
то
picture,
замріть,
the system will ask your
посміхніться,
request. So
не
please
моргайте
freeze,
і
smile,
натисніть після цього
and
accept.
try to
Дозволяю.
accept it, and then you'll be taken a picture of. That's enough.
Ми потім в кінці всі фотографії розмістимо
Afterwards, we're
і
going
в
to share all the
пам'яті, і
pictures
на
on
нашій
our
сторінці
website
форуму.
and also in the chat,
Зазвичай всі
in
матеріали
the forum, I
і
mean,
в форумі вони
forum chat.
зберігаються в
Like,
одному місці,
as you know,
публічні
all
доступи,
the
всі записи,
deliverables are
матеріали.
always available
До речі, ми ще
afterwards.
донаповнимо. Будуть
And
і
we're going to
матеріали, на
also
які
share
сьогодні
even
спікери
more
посилалися.
materials. I
Пані
mean,
Вікторія
those that
надіслала
our
якраз
speakers
листи.
referred
Якщо
to,
ще
Victoria
спікери,
has
які
shared
захочуть
2
поділитися,
reports
будь
with
ласка,
us.
надсилайте, ми
If
все зможемо
our dear
передати
speakers want
до
to
вас,
share
до
more
матеріалів
information
форуму,
to our
щоб
repository,
учасники могли
please do so so that our
ними
participants could
занурюватися.
have access to them and dive
Дякую
into the
дуже.
content.
Нагадую, що
Thank
в
you
нас
so much. I
попереду
want to
ще два
remind you
надзвичайно
that 2
насичених
more days
дні.
await us. They're going to
Нагадую,
be
що
as busy
суботу ми будемо
as today.
планувати, я вже казала
On
про те, що
Saturday, like I mentioned,
знадобляться
we're going to be drawing. This is going to be a
олівець,
masterclass.
щонайменше
You're
6
going to need
кольорових олівців,
pencils,
знадобиться
at least
лайнер,
6 of
щонайменше
them of
молодий,
different colors, one liner,
чорний, і
a
знадобиться
black
щонайменше
one,
один
and you're going to
маркер,
need
звісно,
at
якийсь
least one marker and probably sheets
маркер.
of
Будь ласка,
paper. So please get
долучайтеся.
ready
Також
for the
там
Saturday's
будемо
masterclass,
вчитися, як правильно від бізнес-тренеру, як
and we're going to
правильно
learn
робити,
how to
комунікувати про медіацію, як
communicate
правильно
mediation
робити
in the best possible way.
презентацію, які типові
How to make a
кроки,
presentation
як уникати,
to get a lot of
які
buy-in.
фішечки, як
We're going to
створити
talk about
шаблони
do's and
презентації,
don'ts,
щоб це
how
було
to make
зручно,
presentation
як кольори
templates for your
обирати,
convenience, how to
які
choose the right
підходити
colors and
така,
fonts. So this is going to be a very,
майстер-клас
very
практичний.
practicable
То, будь
masterclass
ласка,
that I'm sure
долучайтеся.
everybody
А
will
завтра в нас
enjoy.
по плану
So
ми будемо
tomorrow,
занурюватися в
we
тему
again, we're
вирішення
diving into
спорів в
the
сфері інтелектуальної
conflict
власності
resolution
разом
in
з представниками
IPR.
Всесвітньої
And we're going to
організації
be
інтелектуальної
having
власності,
and the international representatives and the European Intellectual Property Rights Office. Also, there will be people from the Ukrainian International Property Rights sector, as well as other speakers. This is all happening tomorrow. And also in the afternoon, we are going to handle consumer-related disputes. We now realize that more or less we are covering all the issues and difficulties, and we also established together with Luciana that we're different, but we're the same, and the problems are different, but they're the same at the same time. Well, unfortunately, some of the people think there is no other solution but just to litigate, and that is so true for our country. Some of the members of parliament think that way. I mean, we still have to do a lot of work to disseminate this information, to build proper understanding in our society about how mediation can be effective and how important it is and how it can help handle those challenges that we face today. I'm so grateful for everything that we've discussed today. I also want to thank our technical support, Oleg, and he is going to be with us for another 2 days. This is our technical support. If you're ready, you can also turn on your camera and show up. If not, then we will all show you anyways in the end, because we're so grateful to you for every effort that you've invested. Today, the day was so smooth, without major technical issues that could be related to blackouts or whatever. We could have also experienced shelling and missile strikes, which we do almost on a daily basis. So again, we want to thank you very much. Can't wait for you tomorrow, and we're going to be glad to see you as well. Thanks a lot to all the speakers again and again. And Svetlana, thank you so much for moderating this session.